Good morning, everybody. Let me first of all apologize for the late start. Members of the head table, members of the press, and supporters of the NEVIS Reformation Party, we want to invite you to this press conference for the NEVIS Reformation Party here this morning. I am Halstead Byron, General Secretary of the NEVIS Reformation Party, and I would like now to take this opportunity to introduce the members of the head table, starting from the extreme left, the Honorable Roberto Hector, who is Member of Parliament for St. Paul's in the NEVIS Island Assembly, and Vice President of the NEVIS Reformation Party. Honorable Carlisle Powell is an opposition senator for the NEVIS Reformation Party in the NEVIS Island Assembly and the party organizer of the NRP. And we have our esteemed leader of the NEVIS Reformation Party, Mr. Joseph Walcott Parry, who is a member for St. Thomas's in the NEVIS Island Assembly, and of course, president and political leader of the NEVIS Reformation Party. And on my immediate left, I have my good friend, Mr. Hensley Daniel, who is a Vice President of the NEVIS Reformation Party, and of course, a former Minister of Government. The NEVIS Reformation Party is a responsible opposition party, and we feel that it is important for us to come to the general public, of course, through the press, in press conferences and so on like these, to report to you on very important issues and concerns facing the country. We feel that there are many at this time. The government in power, having assumed office some 9 months ago, we feel that they are not doing a good job, if any job at all. And so the concern is there about their non-performance in government, and also some of the atrocities like victimization of NRP supporters and so on that has been going on for this 9-month period. And so we're here this morning to report to you and to discuss a number of issues which each of the members of the head table will bring to you in presentations. The first presentation is going to be done by the Honorable Joseph Parry, our party leader, and then Mr. Hensley Daniel will make a brief presentation, followed by Mr. Carlisle Powell, and then to be followed by Mr. Roberto Hector. Following that, of course, the floor will be open for you, the members of the press, to ask questions. So with those few words then, I would like now to introduce to you, to present the Honorable Joseph Walcott Parry, opposition leader and president of the NEVIS Reformation Party.
Thank you, Mr. Byron. I welcome the members of the media, the newspapers, Choice, Van, NNC, and I'm very happy that you all are here this morning. Firstly, let me say that this country of ours, this island of Nevis, belongs to all of us. And I would say that we, the members of the NEVIS Reformation Party, have certainly proven to everyone of our love and commitment to the island, to the people of Nevis and the development of Nevis. Therefore, it must concern us when a number of things have been happening in this country that redound to negative thinking and negative reaction of this island of Nevis. So this morning, we want to look at a number of topics. We have to look, first of all, at the finding of the appeals court, and surrounding that, we want to look at the ramifications in terms of what it has done to the Nevis Reformation Party and to Mr. Daniel and myself in particular. Then, of course, we have to look at the matter of names of persons who were put back on the list by order of the court, have now been taken off. And again, to look at the ramifications of those names being put back on and the impact it had on the recent election. Then, of course, we have to look at victimization. And I want to say this, that we speak of NRP supporters, but there is no guarantee that they all are NRP supporters, because some people vote one way this time and the other way the next time. There are divisions for us. And I believe that the people of Nevis have a right to work in their country, and that we can't have victimization of our people. I also want to touch on, or one of the speakers will touch on, the projects. You know that when we were in government, we spoke of growth. We spoke of the need to create employment and to drive revenue to make this country sustainable. And we need to look at what is happening, what we hope to do, and why people are out of work. And finally, we want to look at the federal election, participation in the federal election, and why some of these projects may never come to Nevis. Having said that, let me start with the court case first. Just last week, a decision was made by the Court of Appeal right here on the island of Nevis that Mr. Daniel and I do not have to pay costs. It seems to me that some people have tried to confuse the issue by giving the impression that the court must have pardoned us for whatever reason, and that others would have to pay the cost on our behalf. Let me say this, nobody is paying any costs on our behalf. Mr. Daniel and I have been freed because of a situation. I have here a document, a court document, the Eastern Caribbean Supreme Court Federation of St. Kitts and Nevis in the High Court of Appeal, Nevis Circuit. And it is stamped 26 November 2012. And it reads, High Court Civil Appeal numbers 3 and 5 of 2012 between Joseph Parry, the Premier, Hensley Daniel and their applicants, and Mark Brantley, respondent. Skeleton of submissions on behalf of the respondent. In other words, this document is Mark Brantley's document submitted to the appeals court on the 26th of November 2012. And if I may read the first paragraph, it goes like this. This is an application by the appellants Joseph Parry and Hensley Daniel, inviting this honorable court to revisit, revise, and or modify the order of costs made in this its judgment dated August 27, 2012, by deleting all orders to cost against them. Now listen to this. The grounds upon which the application is based are that this honorable court made a mistake in ordering the applicants to pay the respondents' costs. In that court, overlooked the pleadings and or evidence and made an error in that there was no pleading, evidence or ruling of bad faith or misfeasance against either or both of the applicants, and that the order for costs was in all circumstances wrong and unfair. The application is supported by the affidavit of the applicant Daniel, who deposed that there was no pleading or prayer in the respondent's petition that the applicants had acted in bad faith or were guilty of misfeasance, nor was there any evidence led of such bad faith or misfeasance. In addition, he deposes, there was no finding by this honorable court that the applicants were guilty of bad faith or misfeasance. Now 3, the respondent, is Mark Brantley, contends that this honorable court is functus and accordingly has no jurisdiction to reopen its ruling on the cost incurred in the Court of Appeal and its ruling against the applicant Parry on costs incurred in the High Court. I skip and go to 5. It is clear from the passage before that there were 2 distinct decisions and orders made. Firstly, the court ordered that the costs incurred in the court below be paid by Mrs. Parry and Daniel on the ground that they, along with Mrs. Benjamin and Lawrence, were found to be guilty of bad faith and misconduct in the preparation of the electoral list. The second is that they should be ordered to pay costs incurred in the appeal court on the ground that the appeals were entirely without merit and Mr. Brantley's cross appeal had succeeded. 6, as noted, the application to reopen the appeal and to set aside the order as to cause is based entirely on the absence of any pleading, evidence, or finding that Mrs. Daniel and Parry were guilty of bad faith or misconduct in the preparation of the list. Accordingly, to the extent that the application seeks to have this court vary its order as to cause in the Court of Appeal, the only basis of a challenge appears to be simply that it was wrong. 7, the authorities establish a court of final appeal will only vary or modify its perfected orders if it is determined that the order was obtained as a result of an unfair or corrupted process and that an injustice had been caused. The court will not reopen its order simply because a dissatisfied appellant thinks that the court's decision was wrong. The applicable principle is simply set out in the head note to the report of the leading case of Taylor versus Lawrence, etc., etc., and Pinochet Upguard number 2. Now, they say see also Barclays Bank Pick versus Guy. Now, 8, it is conceded, and this is the applicant, this is the respondent, it is conceded that to the extent that this court based its decision to order Messrs. Parry and Daniel to pay costs incurred in the High Court on a finding that they were guilty of bad faith and misconduct in the preparation of the list must have been seen a case where Homer nodded. The expression Homer nodded means that it refers to the poet Homer of Roman times, fell asleep. It means that a mistake was made. There was in fact no allegation, listen here, this is coming from Mark Brantley. There is in fact no allegation in the petition that they were guilty of bad faith or misconduct in the preparation of the list. There was as well no such finding by the Honorable Court against them in having their names inadvertently associated with the egregious conduct of applicants Benjamin and Lawrence. Therefore, it could be said that they were subjected to an unfair procedure. This is coming from Mark Brantley. Let me repeat, it could be said that they were subjected to an unfair procedure in that they had no notice of an allegation of bad faith and misconduct against them, and accordingly, no opportunity to answer it. I read on. The last sentence in paragraph 8. The respondent accordingly, and who is the respondent? Mr. Mark Brantley. The respondent accordingly concedes that this is an exceptional case where this court will be justified in exercising its jurisdiction to vary its perfected order as to costs in the court below. But this concession is in relation to Mr. Daniel only, because it goes on to try to take costs now away from misfeasance and to the fact that Mr. Brantley did not have the same access to NNC as Mr. Parry and NRP. So you see here, this is a submission by Mr. Brantley. This is a submission by Mr. Brantley and saying that the court made a mistake and therefore he's withdrawing the application in regard to Mr. Daniel. In regard to Mr. Parry, he tried to switch from the misfeasance to the NNC matter. Of course, the court did not take that on as well. So here it is. In November 26, 2012, Mr. Brantley is making a submission to the appeals court, virtually saying neither Mr. Daniel nor myself was accused of bad faith. There is no evidence anywhere. And so the court made a mistake. But then, shortly after, a case is brought to the court against me and against Mr. Daniel, accusing us of doing something mishonesty because of misfeasance and bad faith in the preparation of the list. And what was the case? That because of some criminal activity, we had no right to take part in the NEVIS elections. And I want to say to you, as I've said before, that it hurt Mr. Daniel in his contest in St. John's. It hurt myself as the Premier of the country, and it therefore hurt the party and all the candidates who participated. I want to say this quite clearly, that the people of Nevis respect the court. They have the highest regard for the court. And if such a decision is made by the court that we were guilty, it must have hurt the party and hurt us in our quest to be returned to government. But when Mr. Brantley and Mr. Skeet Scarborough go the next step and bring an injunction against us, accusing of criminal activity or dishonest activity, it hurt us further. And I'm saying that it had to be malicious, it had to be wrong, in the face of the fact that on the 26th of November 2012, Mr. Brantley made this submission to the appeals court. Now, in terms of the court's ruling, what we need to look at is the order of the court. And in the order of the court, our names are taken out completely. Now, if you look at this submission by Mr. Brantley, and you see the admissions here, and you see that our names were taken out by order of the court, it is absolutely clear that there is nothing against us that can cause a reasonable person to accuse us of dishonesty in the preparation of the list. It is not there. I don't have a copy of the transcript. I don't intend to read the transcript. I'm reading what Mr. Brantley submitted to the court that led to the removal of costs. And it is all included inside here. And I want to say to you this morning that both of us have, as far as I'm concerned, our reputations have remained intact. Our integrity is clear and can stand any attack because of this submission and because of the order of the court which was made last week. And I want this matter to reach every member of the public. In other words, the court of public opinion is where I am now laying my case. And I do not care how many lawyers or judges or whoever they bring to articulate on the matter. The information is here, and it stands to reason that we have been proven to be honest men. I also want to make a statement in regard to the preparation of the list. The preparation of the list is done in St. Kitts. The preparation of the list is done at federal level. We could not be involved in any way. We were not involved in any way. And whatever was done to us was extremely wrong. I believe that people make mistakes. The court is made up of human beings. They erred in whatever way they erred. And we cannot in any way validate what they did and try to find ways and means around it. It's absolutely clear. And this must be established, and this must be accepted. The final point I want to make on this matter, we have rights, just like everybody else. You cannot have a court that can arbitrarily make decisions and can easily be excused. I am reminded of two principles that come from the Middle Ages, the feudal era of England, and one had to do with the infallibility of the Pope, which meant that the Pope cannot be wrong, no matter what the Pope said. And the other one was the divine right of kings, that kings were appointed by God so they could do no wrong. We are talking about 300, 400, 500 years ago, and we cannot bring this principle in this modern age and apply it to the court. We, I think, should be guided by what happens in the United States of America and other places when something is wrong, that it can be exposed, it can be examined, it can be criticized, and people, the public, can get a chance to come to a sensible conclusion. The truth is, if we speak that we are a democratic society, we must act like a democratic society. And we must have the organs and instruments that are expected to function in a democratic society. And I'm saying that with no water in my mouth, that whatever happened, whatever mistake was made, we have to accept a mistake was made, and we have to accept that we were wronged. That is my comment first time around.
Thank you very much, Mr. Parry, for those opening remarks, specifically dealing with the court matter. I would now introduce to you, to make a brief presentation, Mr. Hensley Daniel.
Thank you very much, Mr. Chairman, Mr. Byron, and good morning to everybody, and thank you very much for coming to hear what we have to say. I first of all want to speak to, following on from Mr. Parry, to deal with the matter of the case. I want you to find it like I do, and I want you to ask yourselves a question. In a society, in a democratic society in which we live, I want to ask yourself the question, is it okay for a court or anybody to arrive at a verdict against you and then afterwards try to find the crime? So here we have a situation where the right of the citizen, and I'm speaking to my own personal right as a citizen. I thought a principle in law is that one is assumed to be innocent until proven guilty. And that if you went to a court of law without any allegation, it must be quite alarming for the court to rule that you should have been found. I have it here on page 55 of the judgment of the appeals court of August 27, 2012, where the judges are saying that we should have been found, but the judges themselves did not find. So since they are upset that we were not found guilty, they decided to award costs against us. Now, we had reached that stage because there are persons in NEVIS who took it upon themselves to register to vote in St. John's to help the candidate of the CCM. In 2011, 203 persons were identified as persons who do not live in St. John's. Those persons were objected to, the names removed from the list, they went to court, and they formed the subject of the court matter in 2012. 2011. Those same persons were objected to again in 2013, this year, and not a single one of them has shown up to the objection hearing to contend that they have been disenfranchised. Our law is quite clear. You have to establish residency. And if it was that they were wronged in 2011, how is it in 2013 they didn't show up to the objection hearings? To the objection hearings to say that they were wrong. How is it they didn't show up to the objection hearings? 203 persons. So here it is in 2013, in January 22nd, we have an election where 203 persons have been put back onto the voters list, plus 157 of persons whom we have already agreed don't live in St. John's. Both NRP and CCM in this very room, we had objection hearings, and we agreed these people should be off the list. So here am I going into an election, 203 plus 157. Yeah, 360 people. And these, in the 203, they avoided the postman like the plague. And the electoral office had to employ the services of a bailiff to deliver the objection hearing, to the notice of objection to them. And then they didn't need to come. Mission is accomplished. They voted already in 2013, and so they don't need to come back because the mission is accomplished. This is what has happened. And the damage of the court ruling, I think Mr. Perry pointed out that people believe that we were doing something wrong, but yet still these people, the very people who claim that they were disenfranchised, have not shown up to argue their case. I want to make the point also that when the court says of a premier and a deputy premier that they should have been found guilty of bad faith and misconduct, that's a comment which borders on fraud. And those are serious comments to make about people at the top of the society. And the people in the country would obviously begin to harbor doubts in their minds as to their integrity. And when public officials like ourselves are functioning in a particular way, you must understand how very offensive it is to me when in all of my dealings throughout life, I have been careful to associate myself only with those matters which find themselves in line with the law of the country. And so a ruling by the court was like this, clearly was intended to hurt me. And see the hypocrisy of the respondent, Mr. Brantley. He writes to the court in November that, look, you made an error and it's wrong for us to ask us to pay costs. Yet, politically it makes sense to go to the court, the same court, in January, to file an injunction to prevent us from running on the very matter that he has already said to the court is wrong. And that is part of the politics of our country. We pay attention, we are being asked to pay attention not to what is correct, but to what is expedient. So the same court entertained the injunction hearing. The same court entertained the objection hearing, the injunction, and 2 days before the election, 2 or 3 days before the election, I was served with notice to go to court, and I put the information in the out of order bundle because I was being asked to go to court on a matter which had nothing to do with me. I wasn't accused of anything. And I'm just saying that while we want democracy and good governance, we also need to want people with a certain level of decency. And I want to say that the court did not remove the order for costs against me and Mr. Parry because Mr. Benjamin and Ms. Lawrence agreed to pay. The court removed the order because there was no basis for the order. And I also say finally that in our system of law, surprise is an enemy of justice. And I was surprised at this ruling. Surprise is an enemy of justice. And I hope the court and the people understand that. And all those who say that I have been criticizing the court, I think I have been kind to the court, because if anybody in this country is asked to pay fees for things they did not do, they would respond much more ferociously than I have. And the people in the legal profession who say that I am criticizing the court, I am bound to criticizing the court. I have to do this so that the court doesn't do it to other people. How do you reason that you get costs allocated against you for no allegation, no activity, no finding of criminality? Well, that if it is that I can be treated like that for doing nothing. Suppose I did something, and I have to raise my own confidence and question my confidence in the court, and the court has not done itself any good by this ruling. What we had in July 2011, we had an election in which I won the election by 14 votes. In January 2013, we had a selection, aided and abetted by the court. And so there's a difference. And the citizens of the country have to worry that you could be in Nevis having done nothing, and a court of law awards costs against you, or they can even send you to prison. Because if you do nothing, and you can be asked to pay fines which amount to millions of dollars. And you know what has happened? People have gone to the registry to check where I have properties registered. Activists in the Concerned Citizens Movement have gone to check what I have and calculated the value, and have already begun to salivate at the opportunity to be able to get your property if you don't pay the cost at court. And so the court has unleashed a kind of conduct in the country, and it must be held responsible for that. And I say finally, don't expect me anytime to just say that the court made a mistake. It was a deliberate attempt to hurt me politically, and it was a deliberate attempt to hurt us ethically, and to raise questions in the minds of the people about our credibility as ministers of government and as candidates in the ruling party. I hope that this represents a watershed in the decisions of the court, and it is our lowest and darkest hour. Thank you very much.
Yeah, thank you very much, Mr. Daniel, being very forthright as usual. And I know that the press are gearing up to ask the questions, but before that, we have two more speakers. I'm going to introduce to you now Senator Carlisle Powell, who will speak to you on projects and lack of projects by the CCM government since they came to office in January.
Thank you very much, Mr. Byron, and good day to members of the media. Let me just start by adding one closing point to Mr. Daniel and Mr. Parry's presentation, in that one of the areas, when the respondent decided that Mr. Daniel should not pay cost, they tried to pin the cost on Mr. Parry by using the fact that Mr. Brantley had been denied access to NNC. We are happy that NNC are here covering this morning, but I want to make the point that NNC also covered a march which the Nevis Reformation Party had. And to date, we have not seen any footage of that on NNC. So whereas they're recording this morning we still insist that the opposition in the country is being denied fair access to NNC. The same fair access which Mr. Brantley went to court on. So we hope that that will change sometime soon. With respect to our position, the NRP continues to focus on the mismanagement of NEVIS since this dysfunctional CCM government came into office on the 23rd of January. While we are disappointed that NEVIS appears to be in a coma, can't say asleep, NEVIS appears to be in a coma, we should not at all be shocked, because when Vance Amory, as leader of the opposition, and he would say premier in waiting, address the august body known as the Chamber of Commerce here in NEVIS, he addressed the matter of plans and programs should he win. But here was Vance Amory's biggest plan for NEVIS. In response to a question on how they proposed to develop the country, Vance Amory said, and I quote, "When the people of NEVIS have decided, such plans and programs will be developed." That was his response. Vote for me, and when we are in office, we will develop the plans. Now, if any public figure had made a statement such as that in any part of the Caribbean, indeed any part of the world, the developed world, he would have been ridiculed for such a nonsensical statement. But he was allowed to get away with that. So we should not be surprised now that NEVIS is in a coma and that the CCM, they have no plans for the country and are incapable of getting out of neutral gear. But let me say to you why it should have been so easy for the CCM to develop the country and move it forward. When CCM came to office in January, the Hamilton Road project had already started. And Surrey Paving were in the process of doing the road from the hospital going all the way up to Hamilton to the area of Mr. William Griffin. One of the first things that they did was to call in Surrey Paving and stop the project. As we speak, I understand that they said that they have restarted the Hamilton Road project. It has taken Public Works 3 weeks up to this point to dig a hole there at the junction of Hamilton and Government Road to continue the drainage project. Now, if it has taken them 3 weeks, I suppose they will finish the Hamilton Road in about 3 years. But we wait. The Urology Center, which was started under the NEVIS Reformation Party government, and which we had already expended some $340,000 to develop that urology center, not only for the people of NEVIS, but the people of the Caribbean who would have been invited to come to NEVIS to get the services of Dr. Thwaites and his team. Since the CCM has come to office, there has been absolutely no progress on the urology center. Dr. Thwaites himself is unsure as to what is happening to that project. In the meantime, since Dr. Thwaites started coming to NEVIS to do his prostrate checks, almost 1,000 men in NEVIS, St. Kitts as far as away as Antigua and Anguilla have benefited. Where are the men of NEVIS with respect to the continuation of such checks? The CCM government has remained absolutely silent. No developments on the urology center. If you stay with health, let's talk about the New River Medical Center, the cosmetology unit. This is a project valued at some $40 million. During the construction phase, it would have employed some 40 persons because they were going to do prefab buildings. And then 150 persons thereafter in the continuing work of that New River Cosmetology Center. Funding of 16 million or 40 million EC, US 16 million, already secured. And the CCM has decided not to say a word about this New River Medical Center. Let us stay in health and look at the dialysis unit. Unit which was bought by the NEVIS Reformation Party and the government and the people of NEVIS. We expended some $700,000 on getting that unit here to Nevis. But guess what? The CCM has made a decision that dialysis for the people of Nevis was not important. They have gone throughout the length and breadth of the country, and indeed the Caribbean and the world, to say to people that this unit was brought to Nevis without any due care and attention to detail. Well, I encourage you to get in touch with a gentleman named Dr. Gardner, who is based in St. Croix. You ask him how many times he had discussions with the government of Nevis under Joseph Parry, and in particular, the Minister of Health at that time, Mr. Hensley Daniel. Just last weekend in Canada, Mark Brantley, who is the dysfunctional Minister of Health, said to a meeting that only 5 persons in Nevis need dialyzing. And as such, the inference is that those 5 persons are not important. But in the same statement, he said that the Renal Society had a list of about 500 persons who are on their register at various stages of kidney trouble. Now, he should have known that this is not a list kept by the Renal Society. This is a list which is maintained by the Ministry of Health, and he's the Minister of Health. But that simple point escapes him because he's dysfunctional. Now, these 500 persons are people who are living among us. They require attention. And as such, even if it were only 5, it is important for us to understand that these people require dialysis 2, maybe 3 times a week. If they are going to Anguilla, let us take the EFA to Anguilla at $800. $800 going once a week is over $40,000 for EFA only. So if they go 3 times a week, you're talking $120,000 for EFA. Mark Brantley said that it is too much because it would cost the government $100,000 to operate. But I just explained to you that EFA for 1 person 3 times a week is $120,000. It makes no logical sense, but nothing it does make sense anyhow. Let us look again at the area of job creation. Fuel storage. This government negotiated and were very advanced with a $1 billion fuel storage project. That would have seen ships of huge tonnage come into Nevis to bring and to take out fuel. This would have trained 70 persons in the first instance to certification level, 300 persons working on the project, and 150 working permanently thereafter. What have we seen with this government? No fuel storage. None. So in the area of jobs, when the CCM want to create a job here in Nevis, how do they create a job? Not by bringing investment. They create jobs by firing NRP supporters. That makes no sense. None whatsoever. I won't speak about the fisheries project, Mr. Minister Hector. The Honorable Roberta Hector will speak to that matter. But I will say to you that one of the areas where I'm extremely concerned is the CDB water project. This is a project which is valued at $30 million, which started under the Nevis Reformation Party government, but it now seems that that is under attack. Because just last week, Friday, Mr. George Morris, who started working in the water department in 1974 and has 39 years unbroken service, was told to go home because his services were not needed anymore. The Caribbean Development Bank will not take kindly to this when they learn that the project might be in jeopardy. I want to say to you, my people, that geothermal, which they are now speaking of, which they opposed so ferociously when they were in the opposition, I understand they will be signing a new contract next month. That is what they say. We are waiting to see who they will sign the contract with. Van Samri said that geothermal will be in our homes in 2 years. I would love that to happen. Practically, can it happen? I don't think so. But he must know. He is now the new expert on geothermal. And finally, I said to you, my people, the matter of the Amman, which they say will be with us in January. When the Amman Hotel in Gingerland was announced, at a speech day at Gingerland Secondary School by Mr. Joseph Parry, the Honorable Joseph Parry, who was the premier of the country at that point. He was ridiculed. All of a sudden, it is their flagship development. The small point must be made that in the area of jobs and job creation in this country, in the area of investment and attracting investment, this CCM party, which postured itself as having investors lined up to come to the country, is bereft of ideas. They're comatose. The country is in neutral, and the government is fast asleep. Thank you very much.
I too would like to say a pleasant good morning to all. I recognize the chairman, Mr. Byron, our party leader, my colleagues, and media representatives. There are basically three things I would like to comment on this morning. My first concern would be to offer words of thank you to the many Nevisians and the extended families that attended our Sunday night meeting at the Cultural Center in Phillipsburg, St. Martin. We were indeed happy with the turnout, happy with the participation and interaction at the meeting, and so too we welcome the high level of concern and interest shown towards the activities here in the Federation, and more particularly what is occurring in Nevis. The second issue I want to raise this morning concerns the fisheries complex. The general public would recall that a few months ago, I had to respond to the dishonest statement of Premier Amri when he said in a press conference that there was no signed agreement between the NIA and the Japanese government as it relates to the fisheries complex. That statement, we all know, was a false statement. Many of us concluded then that the Premier was deliberate in his attempt to misguide the public. Today I wish to highlight the disingenuous nature and motive of the Minister of Fisheries, the Honorable Alexis Jeffers. Mr. Jeffers has reported to us that the project will be relocated to Bat Village. He has further indicated that the CCM administration were in discussion with the Japanese to finalize the location. Well, I am reliably informed that the Japanese have already communicated to the NIA and Mr. Jeffers that the request for relocation will not be entertained. In fact, the change in location has jeopardized the project. I call on Mr. Jeffers to be truthful and to communicate this information to the country and the fisheries community. I further ask that he desists from giving false hope, knowing fully well that the project would no longer be implemented. What this translates to is that the meaningful expansion of the fishing industry that we had worked so hard with the federal government to achieve has been stifled under the CCM administration. My final comment has to do with my candidacy. Our party has selected me as the candidate for Constituency 9. Today, as I thank the party for the endorsement, I want to ask the constituents on both sides of the divide for their support. It is my wish, of course, together with the support of all, to take the constituency of St. John's, St. Paul's combined to a new level. Our present elected representative at the federal level has in the last 9 months begun what I would describe as a globe-trotting excursion. We are informed that this movement is a part of a public relations package to improve his image. While he is using the country's scarce resources to travel, we would recognize that there are no economic activity at all taking place here in our homeland. CCM as a government has failed to create the regulatory framework and climate that is necessary for meaningful growth. I have sought to analyze the report card of our representative, Mr. Brantley, as a local minister and as a federal representative. Just like Premier Amri, I have found him wanting. For political clarity, I have taken the time to compare his contribution at the federal level with that of the Honorable Patrice Nisbet. This one-to-one comparison is, in my mind, the best judge to the federal representatives. Unlike Mr. Nisbet, who has brought us so many tangible results, I cannot find a single gain that Mr. Brantley has brought for the people of Nevis. In fact, Minister Brantley, Honorable Brantley, has been a federal failure. If there's ever a time that the Federation needs able men of the NRP, that time is now. Going forward, we need servants like myself and the candidates of the NRP party who have demonstrated an ability to govern and to negotiate at the federal level. We need men of action. We need men of purpose, not men of empty rhetoric. Thank you.
Thank you very much, Mr. Hector, for your brief and forthright presentation, and also to you, Honorable Carlisle Powell, for also your presentation.